Hey out there, legal warriors. This is an interesting video in that I'm taking a contrary position to so many people in the criminal defense community. And that position involves whether or not we should file a response or can file a response in a restraining order case if the action also could turn into something criminal. Most people say you shouldn't. I say sometimes you should. If you want to hear why, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. So what's the first rule they teach us in law school or after law school? We're being taught in the criminal system. It's, hey, if you're accused of a crime or you might be, just shut up. Don't say anything, right? Don't write anything. Don't say anything. Anything can and will be used against you. We all hear that. Miranda warning, stuff like that. And for the most part, that's a good rule of thumb. And for the first 28 plus years of my career, it's pretty much what I lived by. And then COVID hit and we had a little more time at the office and we started thinking, sometimes if we have a client who's accused of something and they're innocent, sometimes maybe we're making a mistake by not getting their story out there for a prosecutor to see a different version than what the alleged victim, who in our case we believe isn't telling the truth, is saying. And so we started to, take some very well-prepared clients and some well-thought-out cases and started talking about our side of it, right, on the record. And it turned out to work. And it turned out to be the right thing to do in some cases. And so in this video, I'm going to talk about why that might apply in a restraining order response. So I've done another video about when we might want to talk to the police. This is about restraining order responses. So what do you mean, Lance? Well, a restraining order in Washington state is a civil matter under RCW 7.105, where some person, not the government, is complaining to the court that they want another person, the respondent, to not have any contact with them. We want to restrain, the petitioner does, the respondent, because of certain bad acts of the respondent. So the petitioner claims all these bad acts, right? I was assaulted by the respondent, or the respondent, did something illegal sexually to my child, or the respondent has been stalking me or contacted me 1,000 times or stole something from me. Who knows? So it's a civil matter where they go into court and they write all this stuff down, and the court will issue a temporary restraining order against the respondent. And in this case, let's say it's for some type of illegal touching of somebody, be it an assault or sexually or whatever. Now the respondent has a chance to come into court and file a response about what happened to try to fight the civil restraining order. So what will most defense attorneys say in that case? And we do more often than not. If someone comes to us, hey, should I file a response in this case, Lance? We'll say, oh, whoa. If you file a response, anything you say can be used against you. What if the prosecutor gets it, right? It's committing you to a position of the defense when you don't know what all the allegations will be in the future. But what you do know is you know some of the allegations. So unlike in a criminal matter, we don't have rights to police reports and things like that when the police are investigating. But here in this case, we can see what the petitioner wrote. And we would imagine that the petitioner's claims in what they wrote to the court are going to be pretty similar to what they tell a police officer if they also pursue an action criminally against us. So that could be an advantage for us. Let's think about the reasons why. If we can see what the petitioner has said and it has certain specifics that we can actually disprove, or we can make look entirely crazy from what the claims are on their face, then maybe it is a good idea for us to do a very carefully thought out and well-researched and written response, keeping in mind as criminal attorneys how to protect you, respondent, to say, here's what happened and here's what didn't happen, and here's all the evidence that shows the petitioner is a liar, that the petitioner is crazy, that the petitioner is just full of it and out to get us for other reasons, right? There's a reason why this petitioner is saying all these bad things about us, not because we did anything, but because of X, Y, and Z. They're jealous because of this. They're jealous because, it's a love triangle and they're dating my man or trying to get with my husband. They're crazy. They've always been trying to get back at me as the parent or as the step parent. Who knows? But it's a huge opportunity in some cases for the respondent to get out a story that says way more than they ever could to a police officer or for a criminal investigation. We've even had cases where we've used our protection order response directly in the defense of a charged case. Here's the response. Here's why the petitioner is full of it. Here's what happened during the hearing. And here's why this case shouldn't proceed. And without doing all that work to respond in the restraining order case, we would have been at a disadvantage. We wouldn't have gained so much advantage from what we learned, and we could put it in a way that is easier for the authorities to consider and consume. So sometimes it may be a good idea to use that restraining order response in a way that will not only help give us a better chance to defeat the restraining order, but also push back against any potential criminal charge. Now, this is advanced stuff. This is not something you should do on your own, because the most important caveat is, you could definitely say something that can hurt your case. So when in doubt, say nothing if it also accuses you of a crime. But I'm beginning to think that it's sort of lazy attorney think and safe attorney think to just say, never do it, never say anything because it can hurt you. I don't think that's right. I don't think it's right if we really think about it and use decades of experience to figure out what we can say that can give someone a chance in some cases to win and in some cases to really improve our chances in court. So it's not black and white. It's not 100% of the time we say nothing. So what don't we want to do? And again, I've had a video on this already, but we don't want to say things that enhance us, our chances of being accused of a crime. And we don't want to admit to a crime, right? I've used this example before. Petitioner says, I slapped him in the face. I didn't slap him, I only pushed him. Well, pushing's a crime. So I pushed, I didn't slap. You don't write that, because now you just admitted to a crime. And if the government picks it up, they'll just say, here it is under oath. They swore to it, right? You also want to be careful what you say in court, right? You don't want to say things in court that also can be criminal conduct, right? Yes, I followed the petitioner 4 times, but that was only because I really wanted to know if they were having an affair or not. Well, that might be a good reason why you were following, but that might be stalking, right? And, no, I thought, I didn't think it'd be a big deal if I sent that nude photo to somebody. You don't want to say that, because that could be, unlawful disclosing imminent images, right? And that's a big time no-no in this state, Washington State. So I just wanted to put out there that sometimes it's a good idea to use our restraining order defense to build a criminal defense, because the theory is we want the prosecutors or the government to see our version if it's beautifully laid out and is devastating to the petitioner. Why not do it? Why not do it? It's work, but it's 2 birds with 1 stone. And when it does work, it's a thing of beauty. But it's rare. So think about it. If you have a legal problem, feel free to reach out to my firm. We've been doing this for more than 20 years, and we'll see what we can do to help. We'll identify a way forward, and we will be there for you. Thank you.